Welcome to Synergy's Subject Matter Expert Insight webinar series. This webinar is part of an ongoing series featuring Synergy's subject matter experts giving you thought leadership insights into issues that impact personal injury recoveries. If you have a question during today's presentation, please reach out via email to me at jason@partnerwithsynergy.com, and a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds. A trial lawyer or paralegal's job isn't to know all the nuances of issues to be addressed when a case is over, to know what it takes to keep Medicaid in place or SSI, preserve Medicare and comply with the Medicare Secondary Payer Act, and resolve complicated liens that may be present when a personal injury matter is resolved. Liens like ERISA, Medicaid liens, Medicare conditional payments, MAO plan liens, FEBA liens. All of these issues are things that the trial lawyer or paralegal really doesn't have the time or relevant expertise, knowledge to deal with. They need an expert strategic partner that they can rely upon that can handle it without question. And that is exactly what Synergy is. It's why thousands of top personal injury firms turn to and partner with Synergy every single day. Welcome to today's presentation entitled Lien Resolution in Personal Injury Cases. I'm going to discuss most of the major lien types and relevant resolution issues in this webinar. By the end, you should pick up a few helpful tips to better navigate these liens, ultimately getting to the best possible reduction based upon appropriate reduction argument. Subrogation in liens is a complicated area, and it matters to you as a trial lawyer or paralegal because improper resolution of liens reduces net recovery and can jeopardize future eligibility for the insurance plan. It presents a lot of risk in terms of malpractice and personal liability, especially in the context, for example, of Medicare conditional payments, which we'll discuss later in today's presentation. Given the fact that liens are governed by typically a mixture of federal and state laws, it presents many different issues that trial lawyers and paralegals need to have the expertise and understanding of to properly resolve those liens. The key challenge ultimately is identifying, validating, and negotiating these obligations in an appropriate manner using specialized knowledge and procedural expertise to get to the right ultimate outcome. Now that we've gotten through some of the preliminaries, let's dive into the different issues presented by different lien types that you may come across in resolution of a personal injury case, starting with Medicare. It's hard to overstate the importance of proper resolution techniques when it comes to Medicare secondary payer compliance and dealing with Medicare conditional payments, because failures to properly resolve these types of obligations can result in federal action. So understanding this is critical. The Medicare Secondary Payer Act is a very large statute, but if you boil it down, it creates obligations for personal injury recoveries that are determined by whether it's post-settlement or pre-settlement. The discussion today is going to be centered around obligations that arise pre-settlement. So those are conditional payments that Medicare has made when someone is injured and there is not a payment by a liability or third-party insurer for those medical covered expenses. What's beyond today's presentation is obligations post-settlement. That's the Medicare set-aside conundrum and question, and that's a whole nother presentation in and of itself. But just be aware that the Medicare Secondary Payer Act does have two aspects to it. What's also important to understand is Section 111 reporting, and we'll talk a little bit about what that is and why it's relevant and important. In a few moments, I'm going to talk about some of the obligations that you have as representing a personal injury plaintiff when it comes to Medicare and reporting. Now, the defense has a specific statutory reporting requirement called mandatory insurer reporting under Section 111. What this requires is the defendant to basically do a large data dump of information to Medicare anytime they settle a case with a Medicare beneficiary where the gross settlement is $750 or more. So pretty much every settlement has to be reported by the defense to Medicare, and it's reported by the RRE, which is the responsible reporting entity, which is typically the defendant, or they can hire a third party to report. What's important about this information is that when it's reported, if it's incorrect or inaccurate, it can cause a lot of problems for resolution when the case actually is settled and the plaintiff is trying to resolve the conditional payment. So working with the defense and understanding what is going to be reported, particularly ICD codes, particularly date of injury, those sorts of things, is really important to making sure ultimately that there's not problems on the back end. But just remember that all of this information is going to be reported by the defendant because it's required by law, and there are monetary penalties for failing to report. When it comes to resolving Medicare conditional payments, it's important to understand that all the parties have skin in the game. So a defendant, the Medicare beneficiary themselves, the plaintiff attorney, everyone has potential liability for failing to reimburse Medicare, meaning Medicare can choose who to go after. That's one of the reasons why a lot of times there is today language being included in releases by the defense that pertains to resolution of conditional payments, because they are concerned about their liability, and rightfully so. And as a plaintiff attorney or plaintiff paralegal, you should be concerned as well, because there's liability for making mistakes and failures in this area. So what I was talking about in terms of liability and risk in failing to properly resolve the Medicare secondary payer obligations, Medicare conditional payments, is that the government has become pretty aggressive about pursuing personal injury firms that fail to properly resolve Medicare conditional payments. And you'll see on this slide a list of different settlements that were as a result of failing to resolve a conditional payment or making mistakes. And it's important to understand there's a couple of mistakes that were made here, for example, that are opportunities to learn. So the settlement with Myers, Rodbell, and Rosenbaum was a situation where they'd gotten preliminary information through a CPL, a conditional payment letter, which I'll talk about in a few moments, that Medicare issued, indicating that the conditional payment amount was fairly low, small, but when the case actually resolved and a final demand was issued, it was much larger. And the settlement had been made hinging upon this smaller amount that was due to Medicare. And ultimately, the mistake here was just simply that the portal and this conditional payment letter had indicated lower amounts of money were going to be due to Medicare, but that unfortunately doesn't bind Medicare. The only thing that binds Medicare is the final demand. So relying upon a conditional payment letter or something you see in the portal before Medicare has gotten the details of settlement isn't going to bind Medicare and can result in ultimately problems that occurred here. Another one of these settlements involved a case where one attorney referred the case to another attorney. The attorney who received the case didn't resolve the Medicare conditional payment. Medicare chose to go after the attorney who referred the case out, saying that it doesn't matter whether you are the referring attorney or the handling attorney, you have liability and responsibility. And it's important to note in these particular instances where the federal government has gone after personal injury firms, typically they're asking the firm to then take responsibility and have someone internally that deals with Medicare secondary payer issues and is trained on all of these issues, which, if you take nothing away from today's presentation. Other than that, that's a win in my book, because you really need to make sure you understand the obligations and your team understands them, so that you don't wind up having problems like this because you don't want government action. Given all the risk and liability, I wanted to go through with you the proper steps for personal injury firms in terms of the initial reporting and resolution, ultimately, of conditional payments. So this slide gives you an overview of the process from the plaintiff's perspective that has to happen for resolution of conditional payments. So it starts off with reporting the case to the BCRC, and that requires proof of rep and consent forms being sent to Medicare when you begin to represent a Medicare beneficiary. The BCRC will then issue a rights and responsibilities letter. That letter is kind of the initial starting point. If you don't get that after reporting, that means that something happened along the way, and you need to make sure that you resubmit your reporting documents to Medicare. Once you get the rights and responsibilities letter, from that point forward, you want to use Medicare's correspondence cover sheet. At the bottom of this slide is a URL, and you can Google and find all of the documents on Medicare's website that you need to be using as part of your communications with Medicare. So after the rights and responsibilities letter, 65 days thereafter, Medicare will give you an interim recovery amount by issuing a CPL, conditional payment letter. That was the letter I was saying that in the previous slide, the firm relied upon that in settling the case. You can't rely upon that. It's simply an initial amount. From there, you want to audit that and dispute any unrelated charges. If it's exceedingly low and you know there's been treatment, either one or two things have happened. Either Medicare has not gotten all of the information yet on those treatment dates, or it could be that your client switched over into a Medicare Advantage plan, Part C plan, and I'll talk about that in a moment. But just remember that if the care isn't showing up on the CPL, that doesn't mean that when it comes time for settlement, that number won't grow substantially, because when you give Medicare all the settlement details, that's when they'll issue the final demand. At that point, that's when you know you have a number from Medicare that you can rely upon and is not going to change. So some key takeaways from what we've just talked about is that ultimately, once Medicare issues the final demand, you only have 60 days to pay that debt, or it will accrue interest. And interest starts from the date of the final demand, but it's only assessed if not paid within 60 days. Remember that requesting an appeal or compromise or waiver does not toll the interest from running. It will keep accruing, and it's due and payable for each full 30-day period the debt remains unresolved. Once the 90 days post-final demand expires, the matter gets referred over to Treasury, and then you have a whole mess, because once it gets over to Treasury, it's very difficult to ultimately deal with the situation. Now, once payment is made and Medicare receives it, they'll send a letter stating that ultimately the conditional payment has been reduced to zero and the case is closed for Medicare. With that process background, now let's talk a bit about the resolution methods for conditional payments. There really are only 3 different ways that ultimately you can resolve a Medicare conditional payment. First is pay the amount that's claimed after audit and verification and based upon the procurement cost reductions, which I'll talk about in a minute in terms of the formulas. Second option is you can appeal the amount. That is a very lengthy process, as there's 4 levels of appeal internal with Medicare before you ever get to a federal district court to argue. Meanwhile, interest will continue to accrue, because remember I said that appeal requests or compromise and waiver requests do not toll interest from accruing. The third option, which is the option that we recommend most of the time is a post-final demand compromise or waiver. And if that's successful, Medicare actually issues a refund. And the way that works, I'll explain in a moment in more detail, but basically it involves paying the final demand and then going through the process to resolve through that methodology, but that stops interest from accruing. So as I said on the previous slide, the first option is simply to pay after you've done verification and audit, taking off unrelated claims, and then using one of the two formulas, depending on which one's applicable, under these two particular regulations that reduce the lien based on a procurement cost reduction basis. So option 2 was appeal. As I told you, this is not a very attractive option. Usually it's not all that successful either, but you've got 4 levels of appeal and a very lengthy period of time that will take. And if you go to federal district court, you've got about 420 days until you get there. So going through that process all the while interest is accruing isn't usually the best way to resolve a Medicare conditional payment. So I mentioned option 3 is the optimal way if you're looking to get a reduction of a Medicare conditional payment beyond the typical procurement cost reduction. And by the way, that's very possible and it's quite successful if handled correctly. There are 3 different ways that you can request a compromise or waiver depending on the law that is applicable to your particular case. So there is under Section 1870C of the Social Security Act, a request can be made to the BCRC for a financial hardship waiver request. And that can be done even if the client is receiving a 7-figure settlement. Believe it or not, you can make a financial hardship argument even in those circumstances. The next one is under Section 1862B of the Social Security Act, and that's a best interest of the program type of request. And the next one is Federal Claims Collection Act, a compromise. So between all of those different requests, and they're mutually exclusive, you can make different arguments under different ones. If you're successful, then Medicare actually issues a refund check back to the Medicare beneficiary. At the bottom are some stats from last year for Synergy in terms of our resolution attempts using these methods. So you'll see 71% of the time they were successful. $2.8 million in refunds issued last year to clients we worked with. Average refund was over $31,000, and total refunds since we started offering this services over 17 million, almost $18 million. So as you can see, it is very possible and a very effective way of getting a reduction well beyond simply a procurement cost reduction. Now that we've finished talking about Medicare conditional payments, it's time to turn our attention to Medicare Advantage, MAO, Part C, plan liens. I call these the hidden lien, and I'll explain why, but they're very dangerous because the private contractors that are going after repayment of these debts are very aggressive with their litigation and using the Medicare Secondary Payer Act to claim double the lien amount. So what is Medicare Advantage? Well, it simply takes Parts A and Part B, your traditional Medicare coverage, and Part D, combines them together in a plan that is administered by a private insurance company. So it operates with Medicare dollars, but is privately administered. So it's important to understand that clients can start out in Part A and Part B coverage when they're injured, but then elect into a Part C plan during treatment, which could mean that you have liens from traditional Medicare and a Medicare Advantage plan. And so the Medicare Advantage plans have exactly the same rights under the Medicare Secondary Payer Act as do traditional Medicare. That's important to understand for a couple of reasons, and I'll explain why in a moment. So the reason why it's important that MAOs have the same rights as a Medicare secondary payer conditional payment obligation is because of the double damages provision in the Medicare Secondary Payer Act. While Medicare does not use the double damages provisions, Medicare Advantage plans have used these quite successfully and aggressively to recover double the lien amount if there's a failure to repay the MAO plan, which does happen because these liens sometimes aren't discovered, which is why I said it's a hidden lien. But under federal law, a MAO has exactly the same rights as a conditional payment obligation claimed by the federal government. So the litigation that's arisen in circuits has been over whether a plan can recover double the lien amount. And so in my home circuit, the 11th, Humana versus Western Heritage is the case where the 11th Circuit said yes, an MAO can recover double. That is the law in other circuits. Third Circuit's an example. But in the 9th Circuit and the 6th Circuit, they disagree with the 11th and the 3rd. So you have a split in circuits as to whether there is a ability to recover double, but the risk remains that the plan will try to recover double the lien amount under the double damage provision, and you don't want to be on the wrong side of that claim. The reason why you don't want to be on the wrong side of that claim is because law firms have direct liability and exposure under the MSP. Because remember when I was talking about conditional payments, I said everybody's got skin in the game. Well, law firms have skin in the game. If you miss a Medicare Advantage lien, the MAO or whoever they assign the claim to could come after your law firm for not just the lien amount, but double the lien amount. And they can come after you personally for that. And there are cases, and they're on this slide, where that has occurred. One was a case where we actually assisted a law firm that was defending against one of these claims. That's the Humana versus Paris Blank. You can see it at the bottom. You can Google it. A law firm was sued for double the $191,000 lien amount. Ultimately, that matter was resolved confidentially during litigation, but as a personal injury lawyer or paralegal or law firm owner, you don't want to be in that circumstance. So you really have to make sure that you don't miss one of these liens. Now, I just talked about missing one of these liens, and the reason why they're dangerous is because if you contact Medicare and get a conditional payment amount, they don't give you a Part C plan lien as well if one exists. One tip-off is you contact Medicare and they say there's no lien. You know the client has been treating and you know they're a Medicare beneficiary. That likely means they elected into a Part C plan. But a practice tip here is that you and your team have to conduct a very thorough identification to see if there's any Part C Medicare Advantage plan liens that exist, and you have to have a process to train your staff to find those MAO liens. And one of the key things is making sure your team has copies of all the government assistance and health insurance cards to determine the types of benefits that your client is receiving, and it'll help you hopefully see if there's an MAO plan in play. The thing is that clients can change their coverages during your representation of them. So continually updating this, making sure you know at settlement whether there is an MAO plan lien or not. Once an MAO plan lien is identified, then you've got to take the reasonable steps to resolve that, just like any other lien. But you can use the Medicare compromise and waiver processes that I described earlier, because if an MAO plan is going to avail themselves of the MSPA in terms of its enforceability, the argument is that they should be then responsible for the reductions that are ultimately available through the MSPA with a conditional payment. We just talked a lot about Medicare. Another government assistance program that's important to understand when it comes to lien resolution is Medicaid, of course. And the seminal case is the Allborn case, and I'll talk a bit about that. But there's definitely some nuance with Medicaid because every state has their own third-party liability statutes, and then there's federal law on this subject. So it becomes a little more complicated, but let's explore it a bit together. As I mentioned at the outset in this section, under federal law, every state must have a Medicaid third-party liability statute if they receive Medicaid funds, meaning that when a third-party case arises, Medicaid is entitled to reimbursement if they've paid for the care related to a third-party liability accident injury situation. But under federal law, there is also the anti-lien and anti-recovery statutes, which creates a natural tension between federal law that says that basically a Medicaid recipient's property, which includes a settlement, is protected under federal law, yet the third-party liability statutes say Medicaid must recover. And that's important to understand because it is the crux of the Allborn case, which is very important in terms of limiting Medicaid's reimbursement rights under the law. The Allborn case, which is the landmark case decided related to Medicaid liens, was decided in 2006 by the United States Supreme Court. The court looked at provisions of Arkansas's third-party liability statute and looked at it through the lens of this anti-lien and anti-recovery statutes to figure out what, if any, limits could be imposed or would be or should be imposed on a Medicaid plan's right of reimbursement under a state third-party liability statute. And what the court found was that the anti-lien and anti-recovery provisions of federal law limit a state's right to seek reimbursement of medical expenditures from a Medicaid recipient's settlement with a liable third party. So the holding ultimately is that the federal law allows a state to assert a lien against and seek recovery from the portion of the settlement representing compensation only for medical expenses. Because the federal anti-lien and anti-recovery statutes prevent and protect the Medicaid recipient's property from being invaded by a state to recover damages other than medical expenses. So it's basically saying that all damages are off limits in terms of recovery for a Medicaid lien except for medical expenditures. And the court stated that third-party liability provisions are inenforceable insofar as they compel a different conclusion. So very clear holding from the Supreme Court that greatly limits a Medicaid plan's right of reimbursement against a personal injury settlement. One of the key parts of the Allborn decision, and it's in a footnote, is the use of a pro rata reduction methodology for reducing the Medicaid lien. In Allborn, the parties had agreed in advance to this type of reduction, but now it's been used very successfully as an argument in terms of how to reduce a Medicaid lien based on the Supreme Court's holding in Allborn. And all a pro rata reduction is equitable distribution. You're looking at the total of all damages compared to what was actually recovered. That creates a ratio. Say they're only recovering 10% of their total damages, then Medicaid is limited to 10% of their lien amount by this type of argument under pro rata reduction. And really all it does is sort of mimics what a jury verdict might look like when they allocate buckets of damages. And that's what the court basically talked about in this footnote, was basically the parties had come to that type of an agreement. But it's important to understand pro rata reduction because many times that's what's being argued under Allborn to reduce a Medicaid lien in any state. In 2013, the U.S. Supreme Court was asked to review a North Carolina statute that had a presumption and required 1/3 of any damages recovered in a third-party liability settlement to be paid to Medicaid for their recovery claim. So it was a chance to either overturn Allborn or reaffirm it. And ultimately, the court affirmed Allborn and found that the statute wasn't compatible with the federal anti-lien provision and violated the holding of Allborn, which precluded attachment or encumbrance of any portion of a settlement not designated as payments for medical care. So important reaffirmance of the Allborn case. The thing was, though, was that when the Woes case, which was the case of the North Carolina statute, went to the U.S. Supreme Court, there was a split of jurisdictions related to which part of the medical expenses a Medicaid lien could touch, since that was never addressed in either Allborn or Woes. And that led to the Gallardo decision, which I'll talk about in a moment, which came out in 2022. So that case emanated from my home state here in Florida, and I actually have litigated these cases in Florida through my law practice, which is separate from Synergy. So what I knew was the case was that up until Gallardo was decided, Florida limited the recovery of a Medicaid lien to only the portion allocable to past medical expenses, even though Florida statute had said both damages were available, because there was a holding in a federal district court putting basically a stay on enforcement of that statute. So as you can see, there was a smattering of states that said you could recover from past and future, and then a whole host that limited to just past. So that leads us to the Gallardo case. Unfortunately, I'm intimately familiar with this case and the law that led to it ultimately going up to the U.S. Supreme Court. And the question that was presented to the court in this particular case was whether Florida's statute, which allowed recovery from a Medicaid recipient's past medical expenses and future medical expenses, whether that violated the anti-lien and anti-recovery statutes. And the court said no, and in essence sort of overruled Allborn in some limited exceptions. It made it much tougher here in Florida, for example, to get a reduction, because now we have the future medical expenses in the calculation. So when we have a pro rata reduction, we're looking at, say it's a 10% recovery, but we've got a life care plan that's $100 million plus the lien amount. You take 10% of that, it's greater than the lien, so there's no reduction. Now, this case, interesting just backstory, the federal government argued on behalf of Gallardo and against the state of Florida in terms of Florida's interpretation of the law. Florida and then other states argued on behalf of Marstiller, and unfortunately, Florida prevailed in a 7-2 decision that was delivered by Justice Thomas, and basically just says that the ability to recover from any medical expenses is within the exception of the anti-lien provision, which is the third-party liability statutes. Now, this decision has limited applicability in the sense that ultimately this varies state to state what the state statute says. So Florida's state statute says in their Medicaid third-party liability statute that they can recover from both past and future. Not every state does. And so the importance of this decision is simply to understand that there can be limitations, and you really do need to be intimately familiar with your state law and understand the arguments that are available to you based on the current state of the law as it relates to Medicaid liens. Now that we've covered federal law in terms of Medicare and Medicaid, I'm going to turn our attention now to ERISA, which is another federal law and a complicated one. And many think that today, because of the McCutcheon case, which I'll talk a little bit about later on in the presentation, that ultimately these are super liens, which is not accurate. And you really have to understand this area very well and leverage every possible advantage you have at your disposal to get to the right end result for the client, which is as little being paid back to the ERISA plan as possible. The ERISA statute is a monster, and it's beyond today's topic to talk in depth about the statute itself. But basically, ERISA plans are employer-based health insurance plans, and they are governed by the ERISA Act, which is the Employee Retirement Income Security Act of 1974, better known as ERISA. And every time somebody hears ERISA, if they're a lawyer or paralegal, obviously there's a bit of disdain for ultimately what that means, which is typically a more protracted and difficult fight for reduction of an ERISA lien. But there are ways to ultimately reduce these. You just have to understand where the pressure points are. ERISA plans are written such that they allow for recovery of third-party liability funds when the ERISA plan has paid for health insurance benefits for someone that's been injured through a third party. These ERISA plans can bring an action under Section 502A3 to obtain equitable relief to enforce the terms of the plan, and we'll talk a little bit about that. But the only appropriate relief is equitable, and it's the only enforcement mechanism ERISA plans have to enforce the terms of the plan that ultimately you need to be intimately familiar with to get the right reduction. One of the big challenges when you're dealing with an ERISA plan is that you are going up against recovery vendors. Optum, Equian, Rawlings, Conduit, just a few that you will face off with if you're trying to negotiate and resolve a healthcare lien, that is ERISA. The challenge with that is these are very large companies, typically thousands of employees, that are trained well on the ERISA ins and outs. They've got their tactics that they use that's form driven. They have limited authority to reduce because the plan holds on to the authority. These people are incentivized by bonuses for how much they recover on behalf of the plan, so they can be aggressive about it. And they do deal with other lien types aside from ERISA, but since we're focusing on ERISA, what you have to understand is you are at a disadvantage in going up against these companies because of their resources. But that doesn't mean that you can't prevail. What it does mean, though, is that you really need to understand the law and ultimately be familiar with what a plan has in its arsenal of tools to fight. So really there's two big cases that you need to be familiar with, Sereboff and McCutcheon. Sereboff goes way back to 2006, which basically said that an ERISA plan has the ability to enforce the terms of the plan through the ERISA statute, and that qualifies as equitable relief under the ERISA provisions. McCutcheon, which is often cited by recovery vendors as a case that means there's no reduction available, which couldn't be further from the truth, held that equitable theories such as made whole, common fund, that can't override the clear language of a contractual agreement between an ERISA plan and its member. So what does all of that mean? It just means that the ERISA plan is a very important document for you to become familiar with and understand, because that is what's going to control ultimately. So as I said, the McCutcheon case is often cited, particularly by recovery vendors, as a case that stands for the proposition that there should be no reduction under federal law for an ERISA plan lien, which untrue. The Rawlings McCutcheon memo is still being used today. I got one a few weeks ago from a client, and basically what it says is that, you know, ultimately the equitable principles of common fund, made whole, can't override an ERISA plan contract. But as I said, there are ways to get leverage and reduce the ERISA plan lien, but you've got to know the pressure points. So let's talk about that. But before we get to that, we really need to, when we're analyzing reduction possibilities, is answer a threshold question, which is it really ERISA? Because ERISA only governs employer-employee plans. There are exceptions. For example, if the person is a federal employee, their plan is going to be governed by FEBA, which is difficult, and I'll talk about that in a few minutes. If the state employs that person, state law applies. It's not the federal ERISA law. And if the employer is a church, then state law applies. So those are three important exceptions to understand when it comes to whether a plan is actually ERISA governed or not. The next question, which is critical, and you have to definitively determine the answer, is that plan a self-funded ERISA plan, or is it a insured ERISA plan? So if it is self-funded, then ERISA preempts state law, and you are stuck with the federal decisions from the U.S. Supreme Court that I spoke about. So it's important to distinguish. So the way to distinguish is a self-funded plan is funded by the contributions from the employer and the employee. Contrast that with a fully insured plan, which is subject to state law. That's funded by the purchase of insurance coverage. So for example, Synergy's ERISA plan, because we are a relatively smaller company, 100 plus team members, we have an insurance company that runs our plan. We pay premiums. That's different from having a pool of funds being self-funded that are employer and employee dollars. So how do you figure out if a plan is self-funded or insured? You have to get the plan documents. So master plan, summary plan document, look at the form 5500, ask, right? Those are all ways of looking at it. One thing to keep in mind is if the plan is named by the employer group, for example, it's the FedEx plan, it's likely self-funded. If the plan is named an insurance carrier or titled HMO, PPO, POS, then it's likely fully insured. But ultimately, you've got to figure this question out definitively. Now, if it is ERISA and it is self-funded, those two answers are yes, then what you want to do is do a 1024B4 request. What's that? So it is a requirement in federal law that if you make a request of the ERISA plan administrator, they have to provide a copy of the summary plan description, the master plan, the annual report, any terminal reports, the bargaining agreement, the trust agreement, administrative services agreement. It is a lot of information that must be disclosed to you if you make this valid request. But you have to make the request of the plan administrator. You cannot send the request to a third-party administrator or a recovery vendor like Rawlings, Conduit, Optum. They're not the plan administrator. So if they fail to disclose the plan administrator, then there are penalties for non-compliance, and you can see the two CFRs down below that dictate those penalties. Now the 1024B4 docs are critical because it lets you assess the validity of a plan's reimbursement claim. So why do you need those docs? Because they will tell you how strong of a recovery claim they have, because remember what basically McCutcheon says is that a plan's rights are as strong as they are written contractually, right? So you want to make sure that you review the summary plan documents, the master plan documents, form 5500, right, to understand that. Then it's separate and aside from that, in terms of what you're doing to see about the validity of the claims, is also auditing the claim summary, doing that typical review of whether it's related, unrelated, make sure that everything's correct, those sorts of things, right? That's all part of this. So ultimately, the plan of attack when you're trying to get a reduction is leverage the 1024 before request. Because if there's a failure to respond, then ultimately penalties are going to accrue. And you can use that as leverage for arguing for a reduction. But even more critical is taking a look at the plan language, understanding, does it overcome the made whole doctrine? For example, in my home circuit, there's specific language that has to be used to overcome made whole. Common fund, for example, if language is silent, then ultimately you can make an argument that common fund applies. So those are two critical reasons why you need to review these documents, but also too to see if it reaches to the particular recovery you've got. So for example, does it reach first party benefits or not? So a couple of key points, a couple of reasons why this 1024B4 is the center of a plan of attack to try and attempt to get reductions of an ERISA lien. Now to another area which FEBA is sort of similar to ERISA in terms of the strength of a FEBA plan's recovery rights, and then also military lien resolution. So we'll talk about these two together briefly. So what is FEBA? FEBA is the Federal Employees Health Benefits Act. FEBA covers any employee of the federal government, and federal employees have a menu of qualified plans to choose from, which are approved by the Office of Personnel Management. FEBA's recovery rights are contained within the federal law, and in that provision there is express preemption, so it preempts state or other local laws as it relates to the subrogation or liens, and ultimately these liens are very difficult because of the strength of the law that's on the side of the plans to reduce. When it comes to FEBA lien resolution, the critical and seminal case is the Coventry versus Neville's case. And in that case, the U.S. Supreme Court held that FEBA preempts state law, and such preemption is constitutionally permissible, which makes the FEBA plans very similar to an ERISA plan in that they have very powerful recovery rights. So ultimately what you have to do, which is similar to most liens, is get the plan language and review the documents for weaknesses to argue that allow you to penetrate their recovery language and get an optimal reduction. It's not impossible, but it's certainly more difficult under the Neville's decision. Military liens arise from claims related to either a military service member or their family, depending on coverages. So there's different types of coverages. There's VA, TRICARE, and CHAMP VA. When you are representing someone who's eligible for military coverage, it's important to understand the differences between these coverages, but it's also incredibly important to know the distinctions and know the little tricks of the trade to try and get these resolved in the most expeditious way possible, because the biggest problem with military liens is how long it can take to get one of these resolved. As I said, there are three different types of coverages: VA, CHAMP VA, and TRICARE. They're governed by the Federal Medical Care Recovery Act from MICRA, and it allows the government the ability to recover from an injured beneficiary when there's a liable third party. Again, the most important thing to realize is you've got to start early with these, because it is going to take a lot of time, and you've got to go to the correct branch and people to get the right information depending on what type of lien you're dealing with. Be aware of protection agreements. There's oftentimes a request for you to sign these. We don't recommend doing that because basically it says that there's no fees or costs that can be put against the government's portion of the recovery. Also, there's a question of whether some of these plans can reach first-party benefits. So just be aware of those issues. When it comes to FEBA, a key practice tip is really making sure you thoroughly review the FEBA plan language. You can get that through the OPM's website. Just be prepared for claims of a very robust ability to recover from your client, and you've just got to work on developing a strategy to go after the plan based on any weaknesses that you can find in the plan language itself. When resolving military liens, the key practice tip is, again, promptly request and review all the billing from the military or VA facilities, as there can be huge delays in getting that information. Ultimately, you've got to be prepared to navigate the complex tiers of different review for compromise or waiver requests, and understanding each tier has different applicable thresholds. Be mindful of the issues around attorney's fees that I mentioned, first party coverage. Make sure you examine any state law or policy language that could impact the government's right to recover from your client if it's a military lien. Last and finally, now it's time to talk a little bit about hospital claims, hospital bills, and provider liens. The issues are the same for both, so I'm lumping them together for purposes of this part of the presentation. Typically, a hospital or provider claim or billing rights of recovery are going to come from either state statutes or ordinances, which are going to vary state to state. Sometimes the hospital may have simply a bill, sometimes it may be a lien. So you have to make sure you determine really what the legal rights of the claim are. But in terms of resolution, what it's important to understand is that most states have a limitation on these types of claims, that they have to be a reasonable amount. And often the criteria as to whether it's reasonable is comparing charges to what is full billed to what a patient with Medicare, TRICARE, Blue Cross, or another insurer receives. So oftentimes what we see are hugely, massively inflated figures coming from a hospital that, when we run it through a reasonable analysis, it absolutely is overreaching, and we can argue that based on a reasonableness argument that those charges should be ultimately reduced. So, but it's also key when you're trying to resolve these is looking at really how strong of a claim is there? Is there really a lien, or is it just a bill? And so ultimately that's a key part of your analysis in terms of whether there is a possible reduction available or whether there is a claim at all. In terms of best practices when it comes to hospital liens, you want to make sure you identify and verify any of those claims. You want to assess if the hospital has perfected a lien according to state law, if that is possible under your law. Confirming any insurance payments and whether they're trying to balance bill, dispute balance billing if they're trying to balance bill. Use a variety of different reduction arguments in negotiations, such as taking off unrelated charges, making those reasonableness arguments, applying any statutory limitations or equitable doctrines, and then ultimately making sure that when you do have an agreement, just like in most instances, that you want some type of complete lien release ultimately. After just listening to all that complexity about lien resolution, you may be thinking to yourself, what if I want to outsource this? How do I do that ethically to make sure that ultimately I'm protecting my client, but also protecting my practice and removing the burden of lien resolution from myself, if I'm the one doing it, or my team, and getting back those hours to spend those hours on increasing the value of other clients' claims or moving other cases forward. So let's talk a little bit about what is required if you want to outsource lien resolution ethically. In terms of outsourcing lien resolution, it is important to understand the ethics requirements. So the ABA allows lawyers to outsource certain functions as long as there is a maintenance of some supervisory or oversight role. Now, certain states have defined what this looks like in healthcare lien resolution outsourcing, and a particular interest is, to me, is the New York model, because I think it's actually a really good model to use as a framework. So if a law firm is passing along the cost of healthcare lien resolution, which is typically the case, then what New York requires is that their retainer with their client allows for the outsourcing. So the client's got to give informed consent. The fees charged must be reasonable by the lien resolution provider and without surcharge by the law firm. The lien resolution activities must result in a net benefit to the client, so a reduction. The outsourcing complies with state-specific bar and substantive law rules. And the referring attorney must maintain ultimate responsibility for the work. So if you are going to outsource, how do you ethically implement it within your firm? So first is amend your fee contracts to include outsourcing provisions. Provide clients with information about the outsourcing to secure informed consent. Ensure compliance with state-specific bar rules and substantive law. Make sure that the lien resolution firm that you hire has the competence, expertise, and suitable training to provide those services, and then maintain a supervisory role over the outsourced provider that you're working with. So last point on this is a checklist for outsourcing. So first, as we just talked about, amend retainer and fee contracts, focus on informed consent, make sure that the lien resolution is a reasonable fee without surcharge, that there's a net benefit to the client, that you focus on the state-specific requirements for compliance with bar rules and substantive law, vet your outsourcing partner, make sure that they are the right ones that can deliver the best results and reductions for your client, and then ultimately maintaining supervisory control, as we talked about on the previous slide. All of those things will help you make sure that you are properly and ethically outsourcing to a company like Synergy. If you have any questions about today's presentation, feel free to reach out to me. My name is Jason Lazarus. I'm the founder of Synergy. My email address is on the screen along with my telephone number. Always happy to consult if you have questions about anything that I can help with related to things I covered today that are happening in your practice right now, or if you just want to learn about how partnering with a company like Synergy can make your law firm more efficient and profitable by outsourcing to us, feel free to reach out to me. As a special offer to anyone that has watched this webinar, reach out to me if you want a free copy of my Amazon best-selling book, Art of Settlement. It goes into great detail about all of the issues that I talked really more in an overview fashion about today. So if you want to do a deep dive, just email me at jason@partnerwithsynergy.com and I'll get you a free copy of the book. Thank you for attending today's Synergy Insight presentation. Before we conclude, I wanted to take a moment to tell you a little bit about our team pictured here on your screen right now. Synergy is a mission-focused organization dedicated to improving the lives of the injured as well as their families and freeing trial lawyers and their law firms to focus on what they do best. We all care deeply about this mission. I am so proud of our incredible team that works tirelessly each day to get the best possible results for you and your clients. It's why Synergy has been consistently recognized as one of the fastest growing companies in the US. Contact us today to find out about forming a strategic partnership with Synergy that will transform the efficiency and profitability of your practice. If you want to learn more about Synergy, visit us at partnerwithsynergy.com or give us a call today to find out how we can make your law firm more efficient, more profitable, and ultimately get the best possible lien reductions for your clients.